A North Carolina custody agreement or parenting plan is a legal document outlining parental rights and responsibilities and physical custody arrangements for a child. It usually exists under divorce or separation proceedings that involve minor children. In this video, we'll cover the terms to include in the plan, and the steps to file for custody in North Carolina. We're eForms, the world's largest online database of fillable legal forms. To create your custody agreement, click the link at the end of this video. First, let's review what terms must be included in a North Carolina custody agreement. Legal custody. Legal custody is a parent's rights and responsibilities regarding legal decision-making for their minor child. Physical custody. When parents have shared legal custody, the court can still divide the child's living arrangements as it deems best. Visitation rights. When one parent has sole physical custody of the child, the other can petition for visitation rights to guaranteed parenting time with the child. Communication. Each parent shall have equal access to the child's education, medical, and other welfare-related records. Sobriety and morality clause. Custody and visitation orders can require either parent or both parents to abstain from consuming alcohol and may require submission to a continuous alcohol monitoring system if deemed necessary by the court. Mediation. In North Carolina, custody mediation has the following goals: reduce ill will between parents regarding custody, provide a structured, confidential, non-adversarial environment, provide the parties with informed choices and give them responsibility for making decisions about child custody and visitation, develop custody and visitation agreements in the child's best interests, and reduce relitigation of custody and visitation disputes. Next, let's walk through the step-by-step instructions to file for custody in North Carolina. You can download all forms mentioned in this section at the resource page linked in the video description below. Step 1. Complete the forms. Download, complete, sign, and notarize 3 copies of the following forms: custody complaint cover sheet, civil summons, domestic civil action cover sheet, complaint for child custody visitation, affidavit as a statute of minor child, affidavit of judicial assignment and notice of hearing, custody mediation cover sheet, order to attend, and affidavit of service of process. Step 2. File documents with county clerk. File all forms with the local county clerk. The clerk will register the documents and return the following to the petitioner: affidavit for judicial assignment of notice of hearing, custody mediation cover sheet, and order to attend. The petitioner will pay the associated filing fees. Step 3. Family court office. File the 3 documents from Step 2 with the family court office. The office will issue a judicial assignment and a mandatory custody mediation orientation date. Step 4. Serve the defendant. Serve the defendants copies of the forms. The petitioner can serve the documents personally with a process server or sheriff, by certified mail, by delivery service, or by publication. A process server or sheriff completes the return of service section on the back of the civil summons and refiles it with the county clerk. If the petitioner uses certified mail or delivery, they submit an affidavit of service of process to the county clerk. If the petitioner has to resort to publication, they submit an affidavit of due diligence and an affidavit of service of process by publication to the county clerk. Step 5. Orientation for custody mediation. Mediation is required for all custody and visitation cases in North Carolina unless specifically exempted by the court. The mediation orientation will take place no more than 45 days from the filing date. The parties will receive their mediation date at the end of the orientation. Good cause reasons for the court to exempt parties from mediation are abuse or neglect of the minor child, agreement between the parties for voluntary mediation, alcoholism, drug abuse or spousal abuse, emotional, psychiatric, or psychological problems, residing more than 50 miles from the court, and undue hardship to a party. Step 6. Custody mediation. The parties draft a parenting plan in the mediation. If both parties agree and the mediator approves, they file the plan with the court for final approval. If the parties cannot agree, the mediator issues either a partial plan or a notice of failure to create a plan. The court schedules a hearing to review the evidence. Step 7. Trial and final order. At the hearing and any subsequent hearings that may arise, the judge considers all evidence put forward by the petitioner and the defendant. Based on the evidence, they hand down a final ruling establishing the custody agreement for the child. Start your own North Carolina custody agreement by clicking the link below. If you want more details about the custody process in North Carolina, visit eForms.com, where we break down complexities into simple steps to help you confidently manage your legal matters.